Angelina Jolie, has revealed the painful events that led to her separation from Brad Pitt. What stands out is not another accusation, but how she weaves legal, financial, and emotional threads into one picture. In 2016, after the now infamous private flight, she filed for divorce. By December 2024, it was finalized. Yet the story remains open, not in the marriage, but in Miraville, the French winery where they married, raised their children, and built a family. Once a home, now a legal battlefield. In documents filed on October 6, Jolie wrote, "The events that led to the need for separation have caused emotional difficulties for me and my children." She said she and the children have never returned to Miraville. After the split, she left Pitt full control and residence rights at both Miraville and their Los Angeles home without compensation. A decision made, she says, to protect her children's sense of safety. The divorce ended, but Miraville didn't. The memories she wanted to bury live on in litigation. To understand why her statement resonated, one must see what Miraville represents. Legally, it's a valuable asset and brand. Emotionally, it's the map of a once shared life, the place of their wedding, their twins' birth, and the family's happiest years. When Jolie says she and her children cannot return, she isn't speaking about geography. She's drawing a boundary between property and pain. Assets can be appraised. Memories cannot. Since 2016, her decisions have followed two lines. Separating from the space of trauma while keeping a path open for her children's relationship with their father. She chose to live near Pitt, never requested alimony, and relied on her own resources, much of which remained locked in Miraville. In the language of law, it's restraint. In the language of life, it's peacekeeping. The present conflict began in 2021 when Jolie sold her shares, valued around $64 million, to Tenuta del Mondo, part of Yuri Scheffler's SPI group. Pitt sued in 2022, claiming a prior agreement required mutual consent before either could sell. The case soon expanded into a cross-border commercial dispute involving companies in Luxembourg, property in France, and courts in California. The central questions: was that consent clause valid? Did Pitt's proposed non-disclosure agreement, which Jolie says was tied to buying back her shares, amount to a gag order? And what evidence counts under California law? Each could shift the balance. At the end of 2024, the court rejected Jolie's attempt to dismiss Pitt's case. Not a verdict, but permission for the lawsuit to proceed. The law, like the couple's history, now runs on two tracks. The marriage concluded, the commerce ongoing. Once in the commercial realm, emotions give way to documents, contracts, emails, and drafts. Yet emotion lingers beneath every paragraph. Jolie's filings do not recount 2016's full details but frame Miraville as a place bound to trauma. Her words are precise for a court yet human enough for the public. When she describes leaving both estates to Pitt and finding a new home for her 6 children, a strategy emerges. Withdraw from harm, avoid escalation, and preserve normalcy. Pitt's side insists the case is purely commercial, not personal. That framing pulls the conversation back to contracts, away from the emotional territory where Jolie, as the one who left, naturally garners more empathy. The NDA dispute adds moral weight. Jolie claims Pitt wanted her silence as part of the buyback. She refused, arguing that as an advocate for victims, she could not sell her voice. The court must now decide whether that NDA existed and, if so, whether it influenced the sale's legality. International complications followed. Pitt sought to question Alexander Oleniuk, a Swiss figure linked to the Stoli Group, arguing he had insight into the negotiations. Oleniuk resisted, citing jurisdictional limits, a common hurdle in cross-border cases where one witness can delay proceedings for months. And in the wine business, time is money. Outside the courtroom, the emotional center is the children. Since the divorce, several have dropped the Pitt surname. Zahara first, then Vivian in her theater credits, and most notably Shiloh, who legally removed Pitt from her name on her 18th birthday. Small legal gestures, yet profound symbols of self-definition. In a family under constant spotlight, changing a name is both personal liberation and quiet verdict. Two parallel logics now define Miraville. Jolie's, Miraville is tied to trauma. I withdrew peacefully, refused an NDA, and sold my shares after failed talks. It's a story of autonomy and boundaries. Pitt's, this was a business breach. The contract was violated, and I seek remedy. It's a story of rules and rights. Neither version is illogical. One speaks in human values, the other in legal precision. The court must turn memory into fact, emotion into evidence, and evidence into judgment. For the public, the lesson is humility. Do not leap from headline to verdict. Cases like this unfold slowly, through motions, filings, and revelations. Eloquence does not equal truth, and silence does not equal guilt. The wisest stance is one half step back, close enough to understand, far enough to respect healing. And if one sentence explains it all, it's this: my children and I have never returned to that house. It shows that trauma can have an address, that memory can be